बिस्मिल्लाहिर्रहमानिर्रहीम अस्सलाम वालेकुम। क्रिमिनल साइटेटर में खुशामदीद। और आज का हमारा टॉपिक है रिमांड। इससे पहले दो टॉपिक मैं कर चुकी हूँ, एफआईआर और अरेस्ट। आज तीसरा टॉपिक है रिमांड। वो दो अलग अलग लेक्चर में आप मेरे चैनल की प्लेलिस्ट में सुन सकते हैं। अच्छा जी, रेलिवेंट प्रोविजन है जी इसकी फिजिकल रिमांड अंडर सेक्शन 167 एंड जुडिशियल रिमांड अंडर सेक्शन 344 ऑफ सीआरपीसी। हाई कोर्ट रूल लाहौर रूल्स एंड ऑर्डर्स वॉल्यूम 3 चैप्टर 11 रूल्स 9 एंड 10 ऑफ पार्ट ए एंड रूल 1 to 12 ऑफ पार्ट बी। अपेंडिक्स 25.56 1 ऑफ पुलिस रूल्स 1934। अच्छा जी, प्रिंसिपल्स प्रोवाइडेड अंडर सेक्शन 167। The principles provided in Section 167 CRPC are in fact the guidelines for the court before whom accused persons in criminal cases are produced for physical remand. In addition to the other requirements, it is mandatory requirement within the view of Section 167(3) CRPC that the court authorizing under this section detention in the custody of police shall record his reasons for doing so। 2016 PCRLJ 1773। इन शॉर्ट इसमें वो ये कह रहा है कि 167 के तहत जब भी किसी पर्सन का फिजिकल रिमांड में रहेगी तो वो रीज़न बताएगी कि उसे फिजिकल रिमांड में क्यों लेना है। गाइडलाइन इन हाई कोर्ट रूल्स एंड ऑर्डर्स फॉर ग्रांटिंग फिजिकल रिमांड फॉर एन अक्यूज्ड ऑफ एन अक्यूज्ड। A remand to police custody ought only to be granted in case of real necessity and when it is shown in the application that there is a good reason to believe that the accused can point out property or otherwise assist the police in elucidating the case। रिमांड सिर्फ उसी सूरत में दिया जा सकता है जब बहुत ज़्यादा ज़रूरी हो और एक अच्छा रीज़न मौजूद हो और के जो अक्यूज़ है वो पुलिस को असिस्ट करेगा या फिर मतलब इन्वेस्टिगेशन में कोई ना कोई रोल किरदार अदा करेगा। अगर कोई ऐसा केस है जिसमें इन्वेस्टिगेशन में अक्यूज़ ने कोई बरामदगी वगैरह नहीं करवानी होती तो फिर उसमें अक्यूज़ के रिमांड की ज़रूरत नहीं होती। प्रिंसिपल्स फॉर ग्रांटिंग फिजिकल रिमांड ऑफ एन अक्यूज्ड 1984 PCRLJ 2588। ड्यूरिंग फर्स्ट 15 days द मजिस्ट्रेट में ऑथोराइज द डिटेंशन ऑफ द अक्यूज्ड in judicial custody liberally but shall not authorize the detention in the custody of police except on strong and exceptional grounds, and that too for the shortest possible period। The magistrate shall record reasons for the grant of remand। The magistrate shall forward a copy of his order passed under section 167 CRPC to the session judge concerned। After the expiry of 15 days, the magistrate shall require the police to submit complete or incomplete challan, and in case the challan is not submitted, he shall refuse further detention of the accused and shall release him on bail with or without surety। After the expiry of 15 days, no remand shall be granted unless the application is moved by the police for granting of remand adjournment। The application moved by the prosecution police after the expiry of 15 days of the arrest of the accused be treated as an application for adjournment under section 344 CRPC। Before granting remand, the magistrate shall assure that evidence sufficient to raise suspicion that the accused has committed the offence has been collected by the police and that further evidence will be obtained after the remand is granted। The magistrate shall not grant remand adjournment in the absence of the accused। The magistrate should avoid giving remand adjournment at his residence। The magistrate shall give opportunity to accused the raise objection, if any, to the grant of adjournment remand। The magistrate shall record objection which may be raised by an accused person and shall give reasons for the rejection of the same। The magistrate shall examine police file before deciding the question of remand। If no investigation was conducted after having obtained remand, the magistrate shall refuse to grant further remand of adjournment। The magistrate shall not allow remand adjournment after 2 months, which is reasonable time of arrest of the accused, unless it is unavoidable। In case complete challan is not submitted, the magistrate shall commence trial on the strength of incomplete challan and examine the witness given in the list of witnesses। If the challan is not submitted within 2 months, the magistrate shall report the matter to the session judge of the district and also bring the default of the police to the notice of superintendent of the police district। The magistrate shall not grant remand mechanically for the sake of cooperation with the prosecution police। The magistrate shall always give reasons for the grant of remand and adjournment। मेरा ख्याल है ये इतना मुश्किल नहीं था कि इसको ट्रांसलेट करने की ज़रूरत पड़े। इन शॉर्ट के मजिस्ट्रेट जब भी रिमांड देगा तो वो रीज़न लाजमी लिखेगा कि उसने क्यों रिमांड दिया। Successive remand. Similarly, Section 167 CRPC does not visualize successive and repeated arrest of a person required in more than one case. An accused required in more than one criminal cases when arrested will be deemed to have been arrested in all the cases registered against him. There is no legal bar for interrogating an accused person with regard to the allegations against him in another case. It is rather desirable that when a person required or accused in more than one cases or where more than one FIR are registered against him is arrested and remanded to physical custody, then he should be interrogated about the all allegations against him in all the cases. Instead of acting strictly in accordance with the law, the police since long is following the illegal practice of showing the arrest of the person in one case and on the expiry of remand, it again arrests him in another case. It is commonly known that in selected cases, police would arrest the accused on his release on bail in the first case. It is now here stated in the Criminal Procedure Code and police rules that a person required in more than one case when arrested will be deemed to have been arrested in one case, and he cannot be arrested simultaneously in more than one case. Section 167 CRPC simply says that whenever a person is arrested or detained in custody, the magistrate may authorize his detention in such custody for a term not exceeding 15 days in the whole. The section does not talk of case, it talks of custody only. The longest period for which an accused can be ordered to be detained continuously in police custody by one or more such orders is only 15 days. So, the detention of the accused person required in more than one cases already registered against him for more than 15 days would be illegal. 1992 PCRLJ 131 लाहौर। अच्छा जी, इसमें पुलिस जो 167 है, 167 में सिर्फ कस्टडी की बात की गई है, केस की बात नहीं की। इन शॉर्ट इसमें ये कहता है कि एक शख्स को अगर एक केस में अरेस्ट कर लिया गया तो उसे उसी दूसरे केस में दोबारा अरेस्ट नहीं किया जा सकता, मतलब री अरेस्ट के लिए दोबारा रिमांड नहीं लिया जा सकता। अगर एक बंदे के ऊपर 10 FIR हुई हैं और अलग अलग लोगों ने कराई हैं और अलग अलग केसेस पर मुश्तमिल है, तो उन सब वो पर्सन तो एक ही है ना, तो उसी एक ही बंदे से पुलिस ने इन्वेस्टिगेशन करेगी, ना कि उसे हर केस में अलग अलग उसको इन्वेस्टिगेट किया जाएगा। 3.6 है जी, एप्लीकेशन ऑफ माइंड गाइडिंग प्रिंसिपल्स। दिस कोर्ट एक्सपेक्ट्स the presiding officer to perform their duties with their eyes and ears open as required under the law and pass orders after judicial application of mind and not in perfunctory and slipshod manner, allowing room for mistakes, because these mistakes, whether they are inadvertent or not, reflect upon the conduct of the judge and can be considered as a minus point. We disapprove and depreciate such conduct of the presiding officers, and it should be discouraged in true sense as far as possible. PLT 2005 सुप्रीम कोर्ट 86 1995 SCMR 429। Accused not produced before magistrate. Accused being injured was admitted in hospital, but he was neither produced before the magistrate for remand nor magistrate was requested to visit hospital. Detention is illegal. Accused detainee was granted protective bail 2013 MLD 1359। फिजिकल रिमांड के लिए अक्यूज का मजिस्ट्रेट के पास पेश होना ज़रूरी है और मजिस्ट्रेट जब इजाज़त देगा तो फिर उसको डिटेन किया जाएगा, चाहे वो हॉस्पिटल में हो, जेल में या कहीं पर भी हो। जुडिशियल फंक्शन रिमांड 16 सेक्शन 167 रिमांड ग्रांट और रिफ्यूज़ल ऑफ फिजिकल रिमांड बाय मजिस्ट्रेट इज़ अ जुडिशियल फंक्शन 2005 PCRLJ 1709 लाहौर। डिटेंशन ऑफ अक्यूज इन पुलिस कस्टडी इफ चालान नॉट फाइल्ड इन रिटर्न्स ऑफ सेक्शन 173 CRPC। Effect police officer as per section 344 CRPC is duty bound to furnish justification of detention of accused in custody of challan under section 173 CRPC has not been filed and trial has not commenced. Otherwise, in absence of report of a police officer or challan, detention of the accused would be unjustified and against the provision of law. PLD 2002 Supreme Court 590। No private person can claim physical remand. Magistrate had sent the accused to judicial lockup as he was no more required for physical remand by the police, district public prosecutor, nor any other representative of the state had raised any objection While the accused was being sent to the judicial lockup, state had also not assailed order of judicial remand, and the complainant alone had impugned the same in his private capacity. Section 167 CRPC was clear on the point that any person in his private capacity could not have applied for the पुलिस कस्टडी ऑफ द अक्यूज 2017 PCRLJ 691 कराची 2016 PCRLJ 1566 लाहौर revisable order complainant therefore had got the locus standi to file revision petition order revised by the magistrate refusing to grant further physical remand of the accused in the case registered under section 392 PPC was a judicial function in view of subsection 3 and 4 of section 167 CRPC 2005 YLR 805 आगे हटिए अगला टॉपिक इन्वेस्टिगेशन वो नेक्स्ट लेक्चर में डिस्कस करेंगे थैंक यू सो मच फॉर लिसनिंग अल्लाह हाफिज़